perception which enables one to discern subtle truths.
Hi, everyone. Welcome to another week's episode of the Acuity Podcast, Politics and Culture. I'm the host and CEO of Acuity Medical Law, and with me is my charming, lovely co-host, Amy Hamm. Always great to sit with you for at least an hour every week and catch up on news and interesting things, but we've got a bit of a different style episode today.
Yeah, I'm gonna just ask you a lot of questions about medical malpractice law. But maybe before we do that, how is your week going?
Good. Yeah, it was a good week. I had a lot of shifts this week, so feeling a little burnt out that way. They happened to be pretty good shifts, and we signed up a couple of new clients at the firm. One of the things that I was thinking is that, a marker of success in the medical malpractice space we should consider, but I don't think that we often do, is the number of expert reports that we get that are favorable. And if the case is really viable and things are going well, then and the evidence is strong, both in the medical record, but also through discovery, through oral testimony, then you should have experts who will support the perspective of the plaintiff. And that just keeps racking up. Like, I think that might be something that's worthwhile even talking about explicitly to clients and potential clients and to the audience, that we are really, really successful when it comes to that. We're not out there soliciting multiple opinions to try and find something favorable. Our success rate is like really high. So I'm very proud of that.
Yeah, that's huge, and that's what I try to impart upon our clients too, is like we're different than other law firms. We have the in-house expertise. We know which cases are worth pursuing, and those are the cases we do. We're not going to waste people's time. We're not going to string anyone along. If you have a good case, we'll take it, and we're going to try and win and pursue justice for the people who really deserve it.
Yeah. And then, of course, the other big news is you and I are going to the ARC conference on Monday. So the next episode that you guys will see and hear from us will probably be something that Amy and I are in London recording. It's not going to look like this. We're going to be in some kind of hotel boardroom or at like the convention center or something like that. So I hope you guys will all tune into that, and we'll give you some of the hot takes from the conference itself, what we're taking home, who we're meeting. Hopefully we'll get a surprise guest or two. So we're really, really excited. Looking forward to that.
Very excited. I would say my two sons, they've seen me getting my big suitcase out and packing, and they both pulled out their suitcases because later, it's the very end of August, I'm taking them on a little mini trip on the train to Seattle. And they're like, they saw my suitcase, so they're like, I'm packing. And they've packed away like their favorite clothes, their favorite toys. And I'm like, you guys, it's 2 months away. And they're like, no, we don't care. We're just so excited. We're ready to go. So,
I love that. I love that.
cute.
Yeah. Trips in the summertime are great.
Yeah, I look forward to that. And we'll be very excited to do our podcast from London. Okay, so why don't we jump in?
Sure.
The first question that I'm going to ask you, we'll play a little video first, which was a really sort of viral Instagram reel where you've got a lawyer talking about doctors and medical malpractice suits. So let's play that video, and then I'll have a question for you after.
There's a class that says never talk shit about another doctor. Doctors won't talk shit about one another. Never, ever, ever do they do it. And you can talk to a doctor about leaving a surgical instrument in somebody's body, and they're going to say, well, that's not malpractice because blah, 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 blah. But here's the irony. Here's the irony with all of this. When I was a baby lawyer, one of my very first jobs, we did a little bit of medical malpractice, and the only really good cases that we had sounded exactly like this, all of them. Patient goes into a doctor, something goes wrongly, they don't get straight answers from the doctor, they get frustrated, they get a second opinion, or in some instances they get a third opinion from a doctor, and that physician says, you didn't hear it from me, and don't put my name into this. And if you say this, that I told you this, I'll deny it. But you need to go see a lawyer. That's how we knew it was a good case.
Yeah.
So
great video. Great video.
Yeah. Do you agree? Do doctors, and I think nurses might also apply, do doctors and or nurses really police their own profession?
Okay. So he said a lot of things there. Firstly, doctors, nurses, clinicians try to give others the benefit of the doubt, and they should give others the benefit of the doubt, because wearing the medical hat for a second, I don't know what somebody else saw, did, wrote down, what they explained, what was misunderstood, by the patient. So you always have to kind of do some deference to the person who had a full assessment at that point in time, and that I would not have been exposed to. So we should always give them some other grace in the clinical context. That being said, I don't find it particularly difficult, like we just said a moment ago, finding experts who are willing to go on record that somebody else, when there was an error, that they made an error. So we do have an ethical responsibility to the practice and the profession. We should be honest. If somebody is being objective, then they should be able to say, you know what, that's substandard care, and they should be willing to go on the record. And we've had some success with that. The other caveat that I'll say is to the point about his paradigm of how patients will present as clients to lawyers. Yeah, we hear that all the time. We hear that all the time. Don't, like you and I both, right? Like a potential client calls and says, well, I didn't know anything went wrong, but then I spoke to this guy and he was like, whoa, that sounds bad. So a lot of the time they're being advised by somebody else like, that doesn't make any sense. You should talk to someone about that. And so there is, I would say, quite a bit of that in the medical space.
Yeah. The only thing I would add is, as what I noticed over the years in nursing, you can get professional associations. They'll do courses about proper charting to protect your legal liability. And what I've noticed in that is nobody ever says you should lie, you should cover your ass. It's that you, whatever happens, make sure that you accurately record the truth. So, I think, of course, everyone should be concerned about people lying, but I don't think that the professions encourage that. I think it's more about, if you're truthful and honest about mistakes made, you can cover your liability in that way. Just like chart accurately.
And there's also, too many cooks in the kitchen, right? Like, so if a doctor writes something that is like outright falsehood in a chart, but two nurses, a triage nurse, radiologist, consultant, all write something different, man, you hung yourself. And you don't know what they have all written, and you don't know what they will all write. So I think that there's some collective peer pressure because, you can't get everybody. The idea of these conspiracies, like we've talked about before, is just, it's very, very difficult. You can't really get a huge conspiracy involved with multiple types of practitioners over different departments. So people do tend to write the truth. They might frame it most beneficially, but not everybody's going to have that same lens. So I agree. Yeah, there's a lot of truth in the records.
Awesome. Okay, next question. It's a little broad, but what element do you have to establish to have a medical malpractice case?
Sure. So I like this question because, of course, we focus almost exclusively on medical malpractice, but we take all kinds of other cases. We take MVC cases. I've got like a kind of like a contract case. We take cases against like pharmacies and other allied health professionals. So like there's a whole range that all fall within the negligence broad category. So under the broad category of negligence, there's a finer category of personal injury. Under the finer category of personal injury, there's a very small subcategory called medical malpractice, and that's what we focus on. But in general, negligence has the four classic elements that you have to prove, which is that someone owed you a duty of care, that they were substandard in the providing of that duty, that as a consequence of that, there was a harm that you suffered, and that harm is caused by the substandard care. So those are the four key elements that we have to be able to prove. And each of those has to be proved on what we call the balance of probabilities, which is on 50% or greater, greater than 50% probability that they failed in that one of those four elements. Those are the classic four. In medicine, it gets a little tricky because there can be multiple people who owe you a duty of care. The standard of care depends on what type of practitioner it is. Tying something causally to the harm can be very tricky in patients who have multiple comorbidities and so on. But those are the classic big four elements that you must prove.
Okay. And maybe just to go into it a bit more. So you talked about on a balance of probabilities. Can you just describe, for people who don't know, so in the legal system, there's this idea of balance of probabilities, and there's an idea of beyond a reasonable doubt. What's the difference there? For
sure. So the terms are quite expressive, and they're really carefully chosen language. They have long-standing histories in sort of judicial history. The first is on balance of probabilities means more likely than not. So, for example, if someone has very poor balance, if they've previously had an ataxic stroke and they've got a cerebellar dysfunction and they're prone to falls, and they're walking around in Walmart and they slip and they fall, and they say that there was water there. Okay, Maybe there was water there. Maybe there wasn't water. We don't know. This person is always prone to falling. They've fallen repeatedly. So that might be like, well, possibly there was water there, and possibly something in the environment of Walmart contributed to that fall. But we're not looking for possibly. We're looking for more likely than not. So we need something that says probably. So it has to be greater than a 50% likelihood that the substandard care, that there was substandard care. Beyond a reasonable doubt, there's no exact percentage that says that. We don't really know what that might mean. It might be 95%, 98%, 94%, whatever. But beyond a reasonable doubt is exactly what it says, that there are always doubts. So somebody gets stabbed in the chest and then they fall and they die. Was it the stabbing that did that? Well, I wonder, did they have like a small aneurysm in their brain that also leaked at that? Was it actually a meteor that came down and hit them? There are all these kinds of potentials, causes, and all those kinds of things. Could they have had a seizure and landed on a blade? Like all kinds of insane things. But the point is that this has to be within the realm of reasonableness. So you can always come up with some other option, but it has to be a reasonable option that gives somebody an escape beyond a reasonable doubt. So the standard in civil litigation is lower, 51% or higher. And then in the criminal world is beyond a reasonable doubt, which makes a lot of sense, obviously, because the standard should be different.
Yeah, great. Okay. Next question. You talked about, the elements that you have to establish for medical malpractice. What makes it so difficult to establish causation in medical malpractice?
It's very complicated because medicine is not always an exact science. There isn't evidence that is published, that is extremely well known, that you can always refer to, that in this instance it's always A leads to B. So patients also are, in and of themselves, outside of the lack of evidence, patients are of themselves complicated. So somebody comes in and they were really sick and they were given some medicine that they shouldn't have been, and now they've got an acute renal failure. Well, was that because of the sickness that they had? Was it because they were a chronic smoker? Was it because of the improper medicine that they were given? Et cetera, et cetera. So it's not always easy to identify what is the causal link. And in medicine, there are lots and lots of things that are multifactorial. So, it's a tricky thing. The other component that I will also say is that a lot of the time experts they focus on scientific certainty, right? So they want to know things that are like really, really exact. So for example, somebody has a spinal cord injury and there was a delay in recognizing that and then sending them to a spine surgeon to decompress their spine. Well, it's not always exactly easy to say, well, how much of this was caused by the spinal cord injury? How much of it was caused by the delay? If I had gotten there 1 hour sooner, would that have made a difference? If I had gotten there 10 hours sooner, would that have made a difference? Was how much of the delay contributed to this versus the natural cause of my slip and fall or whatever the case might be? So even from an expert point of view, they don't always really understand that the balanced probabilities means only 51% or greater. A lot of the time they kind of focus on exact scientific certainty for causation, and that's not the standard. So there are a few reasons why causation is a really tricky thing to find, right? The first is that you don't always have that kind of evidence. The second is that things are very often multifactorial, and then the third is from a legal point of view, it's hard to get experts to really understand what it is.
Yeah, that makes sense. And I know I've seen that with at our firm and with our clients is it can be really emotional for clients too, where they see a bad outcome that happened and they see something that happened right before that, and there's this temporal association, and that it's that's
sure.
enough for them to think that is cause, but legally it's so much more complicated than that. And
it's so true.
Yeah. And how do you it's hard sometimes to give people the news this isn't necessally cause.
Right. It's a very tricky thing. And I always appreciate that when clients come and they have those questions and, we do our best to try and really explain this to them. And one of the things that we try to offer is, the anatomic, the physiology, right? Do a deep dive on the research and explain things to them and so on. But, we often will say correlation doesn't mean causation, right? And so even though things are to the patient is so explicitly temporally correlated, I got this shot in my arm and then half an hour later I had a heart attack. It's okay, but the medicine barely circulated and this medication doesn't do that. and you were monitored, and you were really stressed, and you have multiple comorbidities. So I understand why you would think that this medication, this administration was the cause, but it's really, really hard to prove that, right? When there's no other physiologic mechanism. And there's this whole statistical analysis as to, because I always tell people, correlation doesn't mean causation. That's something that's like very simple to understand, and that's been embedded in a lot of the sort of like zeitgeist. But on the flip side, all causation is firstly correlated, right? So the correlation has to be present for causation to be there as well. Yeah. So the fact that they hang on one thing that they think is highly, highly correlated, it's very easy to think that I'm going to go from that to the fact that this must be caused, but it isn't.
Yeah. Exactly. And you can look back on, I looked at this case, I looked at that case, and there was this causation. And it's what you said. It's like that it has to be present, but just, that there was a correlation present, that doesn't mean that it is what you necessarily think it is.
Totally.
Okay. Next question. What is the reasonable patient test?
Right. So this is a really tricky one. And this is a real finicky thing to try and prove and to explain to a layperson. So oftentimes in the context of an informed consent conversation, reasonable person or the reasonable patient is what would the average person who has reasonable expectations and understanding of a particular issue, what would they expect to have been told and to be disclosed for the process of informed consent. So the problem is that reasonable person standard is there's a range. Okay? So if someone comes in and they have an infection of their foot, and I give them antibiotics, and I tell them, there's a good chance that this is going to get better. If not, you come in. And, by accident, by mistake, by chance, that antibiotic was a poor choice. That infection spreads a lot, and it gets much worse. And they have an amputation or some kind of like major injury or whatever. And they come in and they say, well, you know what? A reasonable person should have been told X, Y, Z. It's like, okay, I understand. But on the flip side, who is that reasonable person? And, where does that standard come from? It becomes very tricky. Does the average person really ask all those things? Or does the average person not really ask all those things? One example is in informed consent, you're going to talk about surgical options. And I'm going to say, you know what? If we do this approach, you're much more likely to have, like, let's just say it's a hysterectomy. We're going to have a laparoscopic hysterectomy, and the error rate is really low, and the risk of blood loss is X and Y. The other option is that we can have an endometrial ablation. The other option is that we can have a uterine artery embolization, and these are all the risks and benefits. And you move on with your life. Now, if that surgeon did not disclose, for example, well, blood loss is a big thing here. And because you are a Jehovah's Witness, and you can't get blood products, in a person like you should think about it this way. Now, you see, that person is, quote unquote, not a reasonable person in that they are the norm. They are different. But the question then becomes, not only what is a reasonable person, is what does a reasonable person like this person expect to be told in the process of informed consent? So based on the values that they have, based on the habits that they've exhibited over the course of their lives, based on the particular concerns, interests, risks that will be most important to them. So it's not always a straightforward thing. So it requires some level of nuance about both the individual and the nature of what is being discussed, what the issue is.
That's fascinating. I think that's where you see law getting very into the weeds, especially when you go to trial, where you can see this sort of play out.
Yes. And, one of the things that they talk about on this front is, who gets to decide what that is? Is that medical experts who get to decide what that is? Does a surgeon come in and say, a reasonable person always asks me this is what I always tell? Or is the medical expertise not sufficient or not necessary to be able to determine what is reasonableness? Right? And so the courts have gone back and forth on this. There's been a lot of discussion about it. In general, they have tried to limit the influence of experts on this topic, because it's a legal thing, it's not a medical thing. But the problem is that when you're talking about something very specific, you need the medical expertise about what are those risks, what are those benefits, what are the alternatives. So the courts still kind of require like an expert to weigh in on it.
Right. That makes sense. And it's interesting that it's called the reasonable person, not the average person, because those would be very different concepts.
Yeah, totally. Yeah.
Okay. Next, can you give an example? What is just an absolute slam dunk medical malpractice case?
Okay. So a slam dunk case is basically how far is the departure in the standard of care. Okay. So a slam dunk case is that somebody has acted so far outside of the standard that it's like, oh, they'll never find somebody to defend that practice. So, a patient comes in, I'm having huge, heavy chest pain. They're a smoker, they're hypertensive, they're a male in their 60s. No ECG was done. You're done. I mean, not getting an ECG and failing to recognize that heart attack in a setting that the person does have the capacity to get an ECG. I mean, there are some things that are just so far outside of the standard of care that those are slam dunks. Now, just because you have a slam dunk in terms of the standard of care doesn't always mean that leads to the liability. So, in this instance, they didn't get a screening ECG in triage and the patient waited another hour before they came in and got an ECG then. Well, does that hour lead to their perpetual heart failure? Did that hour delay lead to a valve rupture, right? And so on and so on. So it doesn't always mean that just because it's a slam dunk on the standard of care, that it's a slam dunk on liability overall. Yeah. So, I mean, it's really tricky because there's so much variety in medicine compared to car accidents. Car accidents, slam dunk. The other person ran a red light, caught on camera, was drinking and driving. Boom. I mean, liability is done because it's so egregious in the substandard nature of the driving. But in medicine, it becomes trickier. It's also rare. We have to say that, right? I mean, most physicians are not practicing, even 1 or 2 standard deviations beyond the pale, right? So it's rare. We do see them though, and we've had them and still have them, but it's rare.
Yeah, and when you do see those examples, we're just like, wow, all right. And sometimes it's a matter of it looks like that, but then when you sort of get into the weeds of looking at medical records, you're like, okay, it's not quite as clear cut. There's sort of this has been filtered by the perception of the person experiencing it versus the person providing the care. But those
Totally.
cases definitely do exist.
Yeah. If other team members have literally voiced a concern and one team member has sort of explicitly disregarded that concern, I mean, that becomes very, very difficult to defend. I mean, in surgeries, classic things would be retained surgical instruments. That's almost never supposed to happen. I say that with a caveat because, I mean, we purposefully leave some things to people, but meshes or, sutures or clips or whatever, those are on purpose. But leaving a pair of forceps in someone, well, that should never happen. Right? So those are slam dunk cases for certain things. Operating on the wrong limb, you don't hear that very often.
Yeah.
But they're out there. Right? There's a reason these surgical checklists exist, so it does happen.
Yeah, exactly. Okay.
In the psych world, Amy, what do you think? Maybe failing to take away a dangerous device from someone who's being inpatient or...
Yeah, in psychiatry, it's even more gray because, a lot of the care provided is quite subjective, and what you're doing with patients. I think where malpractice comes in psychiatry is a failure to do really basic things like removing harmful items or violating someone's legal rights under the Mental Health Act, not properly reading someone their rights, informing them of their rights, or depriving them of their legal rights under the Mental Health Act. I think those are the really obvious ones. But then, you get people who, psychiatric medications are really harsh. They have a lot of side effects. It's not an area, I think, that is well researched. We haven't advanced in a long time. And so I think a lot of people feel like they've been harmed by their treatment, but that I guess would go back to what you're saying is that's actually kind of, unfortunately, the standard of care. So there's not a lot
somebody
you can
started
really
on
do.
antidepressants and then they end up having self-harm. And it's okay, but antidepressants aren't magic. They don't suddenly inoculate you to the possibility of self-harm. They slowly ameliorate and help mitigate over time, right? Or somebody gets extrapyramidal side effects from antipsychotics. It's like, well, I'm sorry, but that's what these drugs do. And
Yeah.
I'm like, maybe they're not the best choice, but we don't have a long list of failed therapies here. We're trying things according to evidence. So we do get those phone calls, which is kind of unfortunate, where people are like, they gave me the wrong drug and now I feel terrible. It's like, yeah, I understand, but it's just not the wrong drug. It's not an egregious departure from the standard of care at all.
Exactly. Yeah. Okay, this is an interesting. What is the craziest medical malpractice case that you've ever heard of or seen?
Yeah, I kind of hummed and hawed about this. So the first thing I'll tell you is that in general, it's very difficult to find things that are super egregious, because anything that you look for in case law was kind of equivocal enough that they took it to trial. So, like, of all the case law that I've read, like, you've got my favorite, the Bible of medical malpractice, so it's over there, over your right shoulder.
Yeah, it is right
and
there.
yeah, and a lot of those are kind of like tricky, because if you're reading one, both the defense thought that they had a shot and the plaintiff thought that they had a shot. So it's hard to find one that it's like, psh, that's egregious, but they do exist. Okay. Personally, I don't want to talk about things that are like particularly recent. We've only been at this for 2 years now, just about 2 years. But I mean, like, the kinds of things that I find super, super egregious are when a clinician has done an extremely cursory job on their assessment. So physical exam, history taking, investigations, any interventions. If they've done a very, very, very weak or brief job on that, and the patient was what the nurses have already gathered, what everyone has understood, it's already a very high risk patient. So I mean, like, at the very, very least, you should write down something to suggest that you have gone through the process of thinking about how serious this is. And unfortunately, sometimes we do see where it's like 25, 30 words written, and the patient's risk is like super high. And it's like, my dude, but you and I both know, like, you've taught medical students, you've gone through medical school, you've taught residents, you've officiated exams. You and I both know that history, physical exam, investigations is like poultry, is like nothing. Where's the rest of it? Did you not take this person seriously at all? So I mean, like, those unfortunately do happen, and it's not always because the person is, like, wicked or malicious or malevolent or anything like that. They could be burnt out, or they didn't think that it was that serious, or they missed something in communication. So it's not to suggest that those things are always like a malign, but if you pause for a moment and you look at that even remotely objectively, even the defendant should look at that and be like, that was not enough. I should have written a lot more. I should have protected myself a lot more. I should have been way more detailed in my discharge or disposition advice, something. But it's always amazing to me when I see, like, on exam, vital signs. You didn't write down what they are. You didn't write within normal limits. They are abnormal. You didn't comment on why. Physical exam, heart normal. Okay.
Yeah.
You didn't check fluid status. You didn't write down that they did or didn't have a murmur. Their chart is full of the fact that they have a murmur. Like, they have profound aortic stenosis as their chief comorbidity, and you didn't even write that down. Like, et cetera, et cetera. So you don't see those very often, but you do see them.
That's what I had in my head when you just said that within normal limits, when you're describing, like, this just dearth of charting. And I was imagining the times, it doesn't happen that often, but you just see, like, this really scant note, and then you see WNL for within normal limits. And then you sometimes see it and you're like, that's a doctor that was really tired or something.
Yeah.
It's just like, blah, blah, blah,
quick.
within normal limits, within WNL. And you're like, all right. Not very much information here. Interesting.
Right. And I mean, like, from your side, from like the psych world or from the consultant world, where you have much, much more time and the expectation is far longer, more comprehensive notes, especially if you have a team of learners who, like, go through things meticulously because they're trying to impress you and they're trying to show all they know, then those things are rarer. But the reality is, clinicians who are really hard pressed for time, which is either principally family physicians or emergency physicians, they can write, like, basically nothing. And it's like, dude, even to your own self, even if you want to look back at this note, if you're to look at it again in an hour, you don't even know what you wrote. You can't read it.
Yeah. You know what? This wasn't on our, this is a little bit of this question just came to my mind right now. But I think about it because I do some work at a family practice clinic for a few hours a week. And this issue comes up, and it's happened like for the years that I worked in hospitals, where handwritten notes, a lot of notes are computerized right now, but now like when patients come out of the ED and the first document that I get is their like discharge from hospital, and it's a handwritten doctor's note. And every time I see one sitting there, and it's like I have to go and look at that and determine like, oh, does this patient need follow-up? Do I have to recall them for an appointment? And I look at it and I'm like, oh my God, I'm just dreading, because I know it's going to be like scribble, 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 and I can't make out what the hell it says. So just, is there an issue here with medical malpractice where you have physicians who their charting is totally illegible, and that has maybe led to an issue?
Yeah. Illegibility, so far, in my experience, has not led to an issue. It has led to a challenge, right? Because, I will say that the defendants have all been, thus far as I can tell, very honest. I know what that says, or I can't read that, and but I definitely know I wrote that. And you're like, okay, that's fine. I mean, that could happen to me too. So, there's a certain you give them some grace for that. But on the flip side, you do have, from an administrative law point of view, you have an expectation of record keeping, right? And so a college complaint that would originate from us, on behalf of a client, like the physician can't read their own notes. These notes are not going to be legible by anyone else. They're not legible by other team members that they have in form of communication. The medical risk is very high. So from an administrative law point of view, that's a standard that has to be met. So, you can't get away forever with just chicken scratch. Not at all.
Yeah. Thank you for saying that.
Yeah, it's true. Yeah. And I am notorious. My handwriting is terrible. My notes are not terrible.
Oh,
My
no.
handwriting is terrible. Thankfully, we've moved to an online system where I can type all my notes. And so it's improved dramatically. But my notes have always been really thorough, but ugly. I mean, just looking at my notes, it's really ugly to look at. I have to admit that.
I'm getting stressed out just hearing about your handwriting.
Yeah.
Okay, next question. What should patients do if they think that they're experiencing medical malpractice?
Yeah. There are a few things. Okay. The first is that if you are concerned, you should call an expert. Okay. I am a very, very strong proponent of people advocating for themselves and doing their own research. I don't mind that in the legal world when I have clients who message me, hey, I was thinking about this, and do we take this attack or this route? I don't mind that at all. And I do not mind it as a patient. And a lot of my colleagues are like, oh, they did their own Google. Oh, they asked Dr. Google. Good for them. Why would you not? As if I'm smarter than Google is. I am not smarter than Google. It's going to think of things that I will not have thought of. The difference is the discernment, is the judgment, right? Like Google doesn't examine patients, doesn't do histories. Patients don't always know what are the most salient symptoms and what syndromes apply to what diagnoses. So apart from that, I encourage people to do their own research. But the biggest risk of thinking you can go about that your own, especially with respect to medical malpractice, is it is extremely complicated because you have two major high-level professions that are interacting. You have the legal world, and if you don't have any familiarity with that, you're behind the eight ball. And then you've got the medical world. And good luck trying to master both of them within the timeline that you need for all of the court filings and everything that's required. So this is, unfortunately for the average person, this is one of the situations where trying to do it on your own is a very bad idea. It's a very bad idea. I don't know anybody who would have the time and the capacity to be able to go through this and represent themselves easily. It's really, really difficult. Most lawyers don't dabble in this, right? Like most lawyers are going to be like, I don't do that because it's just too much. It's too heavy.
Yeah. Yeah. And it's interesting. This isn't med mal related, but I covered this story for the National Post recently, and it's like this woman who brought forward a judicial review application, and she's a university professor. She's extremely intelligent. She's really smart. She knows what she's doing. She didn't have a lawyer. She did all the filings herself, put a ton of work and effort into it, and the whole thing was tossed out on a simple legal technicality. And so that's another risk that you run
Yeah.
is like, if you don't know, you have to know medically what's going on, which is really complicated. Google can give you a lot of information, but you don't have the discernment to understand what is relevant, what is not. And then there's the legal system. And when those come together, it's like you have two really overwhelming systems coming together, and the smallest thing can just have you completely tossed out of court entirely. So I agree
Yeah.
with you. It's like,
And
you need experts.
And the process itself is not streamlined, right? Like even for me in this world, like I have an expectation of a certain trajectory for a file, and as you're going through, the defense says, we're taking you for a motion for X. I'm like, okay, I haven't seen that before. I got to go do all this research to figure out that. Or, like you lose a case and now you're going to appeal something. Okay, well, appeals are completely different. I have no idea what that is. I don't know how to do that. I got to do all this legal research. So, it's not like you have like one nice course that you go through. It really swings. There's a tremendous amount of uncertainty and variance within a file. So the best thing you can do is, if you think that you were harmed from some kind of healthcare related thing, you should pick up the phone and call someone.
Yeah, great advice. On the flip side of that, if a doctor makes a terrible mistake, what sort of actions would protect him or her from a lawsuit?
Yeah. So there are a few things. So the first is that there's like what to do and what not to do. So trying to manipulate or change the record, you're in deep water. You don't want to be doing that, right? Now that's not to say that there aren't legitimate processes by which you can do that, right? Like, oh, I read the wrong X-ray. So when I realized that, I called the patient. I told them to come in. I made an addendum to my note, or a radiologist says I added an addendum to the radiology report. So there's like a formalized process that you can go through. You should go through that, mitigate whatever damage is done to the patient. That's like an obvious first thing, and you have the responsibility to do that as a physician. The second thing is you should call your insurer, of course, because your insurer is going to guide you through that. They will get in contact with the legal team, and they'll go through the process of trying to help you through it. The third, oftentimes, the big recommendation is write down your story. Write it down so that you can remember it and think about it, and you have something you can reference going forward. Like a formalized contemporary summary of what happened is very advantageous, because your own mind will play tricks against you. Your memory and your recall is going to change. You're going to end up putting your foot in your mouth compared to what's in the medical record, which will what we call impede your credibility. It doesn't throw out your credibility because nobody remembers perfectly, but it will challenge your credibility. So like writing down like a summary at the time of what you know is another good thing. The last thing I'll say is that I often will describe that the Swiss cheese model of why civil litigation happens is because something substandard happened, the patient was harmed, and the practitioner or the clinician was a jerk. And it's those three things that have to be there. Yeah. We get a lot of calls, and they'll say things like, "Oh, I thought something went wrong," and then I'll tell them it wasn't that person, it was this person, and then they will literally say, "Okay, I don't care. I don't want to do anything to that person. That person's like." They're nice. Like lovely. They're wonderful. They're too nice, yeah. Right? Like they're too important to me, to my life. They care so much. I would never do anything to them. And you're like, okay, good. I don't mind that. Like the sense of justice. Don't worry. The sense of justice has to be that somebody was a jerk and that you are feeling like you have to pursue something in order to rectify a situation. If you don't feel that you need to do that because the person is sufficiently remorseful or has been wonderful to you in the past. So actually, being a nice person in the context of a medical error makes a big difference.
I have to say I totally agree with that, because I've seen it multiple times with our intakes for clients where people say, this isn't something I would normally ever do. I would normally never pursue this. But, if only they had apologized, if only they had been upfront about their mistake, had been honest, had just told me and said, I'm sorry this happened. I'm sorry this happened to you. It won't happen again, rather than someone, ignoring them, refusing to acknowledge,
ghosting
or
them,
trying to displace blame. It's huge, huge.
Yeah. Canceling appointments, ghosting them, this is bad. That is, you may think that it's okay because, the nature of the injury or the nature of the harm is a crisis of confidence and all that kind of thing. But when you realize that something went wrong, addressing it explicitly I mean, generally speaking, is very protective. And also, there's something to be said about, like, there's legislation, there's case law precedent that says apologizing doesn't mean that you're guilty, doesn't mean that you're liable. So
Right.
saying, listen, I'm really sorry that this happened to you, this is where the error happened, or whatever the case might be, actually goes a long way to try to address the situation, and probably to diffuse it a lot.
Huge. It's huge. Very interesting. Okay, this next question, it's a bit more general. So do you always need to have an expert witness or expert witnesses in a medical malpractice trial?
Basically, the answer is yes. Everyone in the legal world loves to, like, always put in these caveats, well, not always, well, in these situations, and so on and so on. The answer is basically always yes. The standard of care has to be commented on by an expert, and causation almost always has to be explained to the trier of fact by an expert. Basically always. The very rare occasions are things like, the surgeon slipped in the operating room and put the scalpel through my face. Okay, you don't need an expert to say you should not slip in the operating room and stab someone.
Yeah.
So, like, there are very, very rare occasions that are, like, basically ludicrous, but otherwise it's, you should always get an expert. Yeah, you need them both for standard of care and causation. And then there are other types of experts as well, I should say, like, one of the ones that we use very often is like a life care planner. So, for example, somebody was misdiagnosed or mistreated and they have really complicated heart failure. So I can diagnose that, and I know what that kind of clinical trajectory looks like, but I have no idea what the cost is of that. What does that mean financially to a person? Well, there are experts out there who literally know these things extremely well. And they go out there and say, the average person with this kind of class of heart failure sees their cardiologist 3, 4, 5, 6 times a year for the first 2 years, then once a year, then twice a year. They usually have this many setbacks. They usually have to be readmitted this many times. They usually get these complications, and so on and so on. And then all of that comes to me, and I put that as part of the proposal, so I have a sense of what the consequences are. So there are many different other kinds of experts. Another one is obviously actuaries. Like, I can read a CRA statement and say, all right, well, the delta in your income after this injury was X. But actuaries are way, way slicker than that. They'll compile not only income loss, but benefits and, opportunities going forward, and what that's going to mean to your retirement, and what that's going to imply for sick leave and insurance costs going forward. And they know all these other things. It's a whole expertise to themselves. So yeah, almost always you need a medical expert for standard of care and causation, but then you need other kinds of experts to truly understand what is the totality of damages.
Very cool. Actuaries sound to me almost like fortune tellers, or like they're reading the
Yeah,
future.
oh yeah. Yeah, that's what they do. Like, these huge tables they go through, but they also know what questions to ask, right? I mean, like, if you gave me all the actuarial data, that would not make me an actuary, right? Because I mean, like, the analysis, the assumptions that go into it, the which tables and how to look at things, how to prioritize things is, like, extremely challenging. And Amy, one of the things that we get asked a lot is, what's my claim worth? And it's very difficult to answer that. That's why there are these experts. So most of my colleagues, the ones that I've trained with and everyone, they really hate that question. I don't mind that question. I don't mind people wondering. And I kind of give them a ballpark as best as I can estimate. But the problem is that there is, we have like an ethical responsibility to not mislead people. And if it's not my expertise and there's a lot more information that's going to come out, I can't know what it is, right?
Yeah.
Greater than 50 grand, greater than 100 grand. But I mean, in the absence of knowing more and all the details that you get from discovery and from all the medical records and the financial records, there's a lot of information there before I can confidently say this is the approximate range.
Yeah, and people sometimes are just, purely motivated by a sense of justice, and the damages aren't necessarily important, but you have to take into account all these factors, like the amount of time you're going to spend in litigation. Will costs be awarded against you? The psychological distress of potentially, what if you're going to be cross-examined or something? There are so many things to consider, and in sort of your passionate anger about having been done wrong by, maybe you're not thinking about all of those. So that's what I really like about Acuity too, is like we try to set people's expectations and say, this is a realistic view of like what you might go through, what might happen because of pursuing litigation. So you got to really think about whether it's worth it for you.
Exactly. And then, to your point, the timing changes the calculation entirely. So, in the first month after some kind of injury, when you're in the middle of an intake, not only do we have no information, but even the patient, the amount of information that exists in the ether is insufficient because you're going to change. Maybe you get better. Maybe you'll get worse. Maybe there are complications. So we don't even know what it's going to be. What are the consequences to your work? Will you be able to return? I mean, there's just way too soon to even be able to get the data to know. And then, exactly as you said, when and if a settlement is going to be reached, how that's going to mitigate against the totality of the value is also very different. So, for example, if a case is worth, for simplicity's sake, $200,000, okay, and that is let's say its true value, right? Like if Jesus comes down and tells you the actual valuation of your injury is $200,000, and you know it with a certainty, that doesn't mean that that's what you're going to get. Not at all. Because, the defense might say, well, there's a 10% chance that you're going to lose in trial. So that means that's not worth 200. That means that's worth 180. Because now you have to subtract the risk of getting zero at trial. The other thing is the timeline. Do you want $125,000 right now in your pocket? Or do you want $170,000 in 2 years from now? Right? So just because we give you a value of where this might be, doesn't mean that that's what you're going to get, because you might make decisions yourself that are going to completely change where that is.
Exactly. Yeah. So many nuances to trying to understand this and know what's best. Okay. Next question. This goes in more into the legal language again than the next couple of questions I have. So the first one is, what is vicarious liability and why does it matter in medical malpractice?
Yeah, it matters a lot. And it's also kind of topical. It was a big thing last year, and the year before. Not as much now, but it is a big thing. Vicarious liability is when someone is liable on behalf of someone else. Okay? So that's basically what it means in lay terms. So when if a nurse does something wrong and harms a patient, you don't actually sue the nurse. You sue their employer, the hospital. The hospital has an arrangement as an employer with their employee that the insurance comes from the employer. So that's the other thing, is that sometimes it may not be the operator, right? It might actually be training or a system problem, in which case, even though the error happened because of a nurse's physical hands or physical capacity, that doesn't mean that it was literally her fault. So someone else is vicariously liable on her behalf, which would be the hospital. The reason I say that it's kind of topical is because there was, I think 2 years ago, a year and a half ago, in New Brunswick, there was some risk that specific nurses were going to be named as individuals, not the hospitals that they are employed by. And at that time, Blaine Higgs, the premier of New Brunswick, was like, if anyone tries that, I will pass legislation so fast absolving the nurses and putting that you will go nowhere with respect to your file. Oh. And yeah, so that was good, that is good, as opposed to each nurse paying their own individual rates and so on. And it also puts a lot more stress on hospitals to do education and training and orientating in the context of their department and so on. So all that is very valuable. It's important. But that's all that vicarious liability means.
Interesting. I don't know if it's the same, excuse me, in Atlantic Canada, but I know because I hold a nursing license in BC and Alberta, and in both provinces you have to have your own insurance, liability insurance. Yeah.
Did not know that. And I mean, certainly there are some places in which that would be the case, right? I mean, like an NP in her own clinic, she cannot be like, oh, I'm just an NP, right? Or if you're a nurse, but you're part of like a family doctor's clinic, it's not necessarily that the clinic is going to hire you and say, don't worry, we'll cover your insurance because you have my oversight. It might be sort of like cut out part of a contract, like actually you need to pay for your own insurance and you can always ask me questions and you can mitigate your insurance by this, but otherwise you're on your own, right? So I guess there's like the capacity for that, but in general that's kind of how it works.
Interesting. Okay, the next question, again about legal language, it's what is the danger of hindsight, and then again, why does it matter in medical malpractice?
So I don't really like the term "the danger of hindsight" because it's usually favorable.
Sounds very cool.
So, but it's usually favorable to me. So I like hindsight bias, right? It's a big problem for defense. So, you know, we let's just take, for example, an emergency doc, right? An emergency physician could see 4,000, 5,000, 6,000 patients a year. And they might be doing things that are like extremely routine and they think nothing of it. And then there's some kind of an error. And they might say like, well, this is what I've always done. This has always been the case. Now, in hindsight, that event looks much more obvious because you know what the harm was. You don't have the benefit at that time looking prospectively what the risks are to that kind of a behavior. So the hindsight bias or the hindsight risk is that to a trier of fact, a judge or a jury, they're going to look at something and be like, well, obviously if you do that, there's going to be harm. Well, obviously if you do that, that's substandard because we see that there was substandard or that there was a harm in this instance. So defense has to kind of like fight against that and remind the trier of fact, like, listen, try to put away the fact that there's hindsight here, that the patient did suffer a harm. Just look at it at the time, how they presented at the time, what they said at the time, how the decision was made then. Don't look at it, well, knowing now what we know, should he have done something different? Because that's completely different.
Yeah. It reminds me of when you see people who won the lottery and you almost always hear their story afterwards where they go, I never buy lottery tickets, or this one time I was driving home and I thought I'm just going to stop at the store and I have an extra $5 in my pocket. I'm going to do it. I'm going to do it just this once. And then the thing happens.
Right. And then people are going to be like, oh man, like the next time I have that inkling, I should go and do it. It's like, yeah, but you're getting a bias from the fact of this success story. You're not looking at that thousands and thousands of times that people have made that same decision and not won the lottery, right?
Exactly.
So you have to look at it sort of contemporaneously.
Do firms sometimes advertise a high number of wins simply by virtue of having a large number of lawyers, and therefore the number of wins seems much higher than sort of a boutique or medically niche firm like Acuity?
It's a good question. So total wins, I would say like on an absolute scale, is not particularly impressive. Because if you take a ton of cases and you lose a bunch of them, but you win a bunch of them, then overall, I think it's like the ratio that matters. It's the relative number compared to your total number of cases. So to me, the medical literature suggests that a successful case against the CMPA, which is the insurance company for doctors, on average is about 15%. So about 1 in 6 cases is a victory. I have said many, many times that if I don't bat 80 to 90%, then I should kill myself. Like I should just jump off a bridge because I mean, like with my knowledge base of what I have, with my ability to corroborate based on evidence, based on what I see, based on what I hear, and I talk to my experts. I mean, if we're not batting way, way, way higher, then I would call that an egregious failure. My mentors have all told me, if we hit 50%, we are laughing. 50% would be a spectacular rate of victory. But I think you and I, Amy, hold ourselves to a much higher standard than that. Now, that's not to suggest that we shouldn't take some cases that are contestable, right? We should. So no one should have a 100% win rate. If you have a 100% win rate, then that means that you did not take some cases that you might have been able to win that had you fought hard enough. So we should not be shooting for a 100% win rate. But I think like 80+% is something that is attainable and also does our clients the best service because that way we are fighting really hard for them, but we are not misleading them with the chances of success.
Yeah, great answer. It's like there's a difference between if you're fighting for justice for clients, that you're going to have to lose some cases. If you're only winning, that means that you're only, helping people in the easiest of cases. So that's a reflection of the ethos of your firm. And that's not our ethos. Yeah. Okay. Should a plaintiff always file a college complaint? So college being the regulator of a medical professional prior to filing a malpractice case?
No, not necessarily. They are different streams. Filing a college complaint can lead to a sense of justice because you can get a reprimand or a censure or remediation. So there are other options for correction that might lead you to the sense of justice, but it doesn't lead to any kind of compensation. It's another added headache. The college might side against you, and then that could feel deflating or defeating. So I wouldn't suggest it. The other thing is that, if the defendant is generally speaking a nice person, but you have been harmed, then filing a college complaint is kind of just nasty, right? So I often will recommend to people, if you feel like you are particularly aggrieved and you want to, or you would like us to on behalf of you, then we are happy to accommodate that request. But it's kind of nasty. The third thing is that the defendant themselves have a responsibility, for physicians anyway, I don't know about nurses, but a doctor, if they are alerted that they are being sued, they have a responsibility to contact their college and let them know. So in a sense, the college is always advised. If there's a settlement, then the defendant gets the luck, or the privilege, I should say, to be able to define, well, what is the nature of the settlement, and it went away, and there was no big deal, and everybody was happy, and you don't have to disclose all the details of what the money was, and what you agreed to, and what the liability was, and so on. But if it's a court decision, then you're kind of screwed, because whatever the court decides, colleges must accept. So they go based on those findings. So, so it's complicated. You shouldn't always contact the college.
Yeah, of course. And we do sometimes in certain cases, depending on the circumstances, go, what would make a lot of sense right now is not a medical malpractice lawsuit, but a college complaint, and we can help you to do that. So it's really case by case.
Totally. That's right. So sometimes it's both, sometimes it's one or the other.
Yeah. Okay, let me see what other questions. In general, what are some tips that you would give a patient who's been harmed, but the damage is really not substantial enough to warrant a lawsuit?
The bane of our existence, the most difficult and challenging thing that I have to do, that we do here, sort of like in our routine. So let's just say a 93-year-old demented patient who has some low-lying simmering cancer, and they were given some kind of toxic dose of medication and the patient died. Obviously substandard, kind of a slam dunk from that point of view. The harm, basically nothing. So the success of winning that at trial or getting a settlement is high. The cost to us to take on, the psychological impact on the client is comparatively much too high. So what we do is we educate the client, we advise them of all of those things. We try our best to come up with what the damages assessment is going to look like so that we can advise them as properly as possible. But the truth is that we unfortunately have to reject a lot of those cases. We have to, because if it costs me 30 grand or 40 grand to run a file, both of my own time and so on, but the value of the claim is only going to be 20 grand, then literally I've lost money just trying to do that. Right? Yeah. And let alone the fact that my time also has a value to other people, other files that I haven't taken. Right? So from an access to justice point of view, taking that on, even if it's a strongly liable case, is just like a really, really difficult thing to society for us to do that.
It doesn't always make sense to take a case. And I know that was hard for me too when I started with the firm, because I've seen people be really upset because, to them, they were harmed, they were let down, and injustice has happened, and doesn't necessarily compute, or at least not when they first get a bit of, the feeling of rejection. And, totally. I think when people maybe reflect on it, they'll understand, but it is really hard, because that's so overwhelming for a patient, is the sense of injustice and wrong and the harms that they've suffered and the symptoms that they're going through. Those and the fact that we reject a case doesn't say that those are not really important, really harmful things. Totally. We totally recognize that. But at some point, like you said, you have to be practical, not only for yourself, but there are other people that we could be helping as well. And this is just unfortunately not, like, if you're looking at it from a utilitarian perspective, this is not something that is worthwhile to pursue.
Yeah. And I mean, like, a lot of the time, those potential clients get some sense of closure from that, right? They're glad that they reached out, and we do our absolute best to provide that sense of closure, to validate their feelings, to validate their concerns, to validate the fact that this was substandard, to give them the options of administrative law or hospital complaint, or write a letter to some kind of MLA or MPP. But in general, it's hard news. It's breaking bad news to tell them that. Oh yeah,
absolutely. Okay, last question, and it's a fun one. And my question is, what is more fun, being a doctor or being a lawyer?
I love this question. So I will tell you that the emergency department can be insane. And there is euphoria, there is a sense of meaning and reward that comes from something that is like extremely, extremely acute, life-threatening, that you manage to intervene and make a tremendous difference in. So, like, let's just say that 20 to 30 times where, you literally feel that you did something heroic. That in the emergency department, as that feeling, the personal validation, the level of success, the gratitude from your teammates, from the patients is, I imagine, almost impossible to compete, right? I mean, like, you probably police officers doing something and saving the day or something like that, soldiers saving their wounded teammates, but we're talking like that level of reward. But that also happens basically never, right? Like 90% of what I see is like coughs, colds, sprained ankles, chest pains that are benign, ruling things out. And so from the mundane point of view, from the day in and the day out perspective, the law stuff is far more stimulating, far more interesting, and on average, more rewarding, right? Yeah. Because what we do at Acuity, you're hard pressed to find another firm that can do what we do. So that's not the same thing in the emergency department. Like for somebody who comes in with a lower respiratory tract infection or a pyelo and they get antibiotics from me or the next guy, I mean, I'm not going to feel particularly heroic. You do your best. You smile, you're kind, you're nice to the patients and so on because it matters to them tremendously. But it's completely mundane to me. But in the law world, every client, every victory, every positive report, every discovery that goes well, there is an ecstasy with that is very meaningful.
Yeah.
So everybody, appreciate you tuning in as always. Like, subscribe, but most importantly, comment. We love to read the comments. We get lots of good questions, and that's part of why Amy and I go through this exercise. And of course, we'll talk about this again, and we'll have more detailed questions. But we will tune in next week from the Alliance for Responsible Citizenry in London, UK. So I hope you'll join us for that.
My friends, let us consider that acuity is the refined clarity of thought and perception which enables one to discern subtle truths.